Lesson 42 continues with the Gideon versus Wainwright case. 1960, let's see, previous, 64. Gideon versus Wainwright. So we have this burglary occurring at this pool hall, actually, in Panama City, Florida, sometime between 8 a.m. and or midnight and 8 a.m., June 3rd, 1961. Someone broke a door, smashed the cigarette machine, stole a record player, and stole money from the cash register. Later that day, a witness reported that he had seen Clarence Earl Gideon in the pool room around 5:30 that morning, leaving with a bottle of wine and money in his pockets. Based on this accusation alone, the police arrested Gideon and charged him with breaking and entering with intent to commit petty larceny. Larceny is theft. Gideon appeared in court, was too poor to afford counsel, whereupon the following conversation took place in the courtroom. The court: Mr. Gideon, I am sorry, but I cannot appoint counsel to represent you in this case. Under the laws of the state of Florida, the only time the court can appoint counsel to represent a defendant is when that person is charged with a capital offense. I am sorry, but I will have to deny your request to appoint counsel to you in this case. A capital offense, of course, is one in which involves the death penalty. Gideon's response: the United States Constitution, the Supreme Court, says I am entitled to be represented by counsel. Therefore, without counsel, Gideon was forced to represent himself, to act as his own defense, emphasizing his innocence in the case. Nevertheless, the jury returned a guilty verdict, sentencing him to 5 years in the state prison. From his prison cell at the Florida State Prison, making use of the prison library and writing in pencil on prison stationery, Gideon appealed to the Supreme Court in a suit against the Secretary of the Florida Department of Corrections, H.G. Cochran, who later retired and was replaced with Louis L. Wainwright. Gideon argued that he had been denied counsel and therefore his Sixth Amendment rights, as applied to the states by the 14th Amendment. The Supreme Court assigned him a prominent Washington attorney who actually later became a future Supreme Court justice by the name of Abe Fortas. The Supreme Court ruled in favor of Clarence Gideon. Poor defendants have the right to a state-paid attorney. Now, understand that this is only in situations in which the defendant could be sentenced to 6 months in jail or more. So what happened to Clarence Gideon? About 2,000 convicted people in Florida alone were freed as a result of the Gideon decision. Gideon himself was not freed. He did get another trial. The retrial took place in 1963, 5 months after the Supreme Court ruling. His lawyer, Fred Turner, picked apart the testimony of the eyewitness, Henry Cook. His opening and closing statements suggested the idea that Cook likely had been a lookout for a group of young men who had stolen the beer and coins from the Bay Harbor pool room. Turner also got a statement from the cab driver who took Gideon from Bay Harbor, Florida, to a bar in Panama City, Florida, stating that Gideon was carrying neither wine nor beer nor coke when he was picked up, totally refuting the statement of the witness. The jury acquitted Gideon after 1 hour of deliberation. He died at the age of 61 of cancer. The Attorney General at the time, Robert F. Kennedy, on Gideon's legacy. If an obscure Florida convict named Clarence Earl Gideon had not sat down in prison with a pencil and paper to write a letter to the Supreme Court, and if the Supreme Court had not taken the trouble to look at the merits in that one crude petition among all the bundles of mail it must receive every day, the vast machinery of American law would have gone on functioning undisturbed. But Gideon did write that letter. The court did look into his case. He was retried with the help of competent defense counsel, found not guilty, and released from prison after 2 years of punishment for a crime he did not commit. And the whole course of legal history has been changed. Gideon versus Wainwright. You have a Sixth Amendment right to counsel, to a state-appointed attorney. If you cannot afford an attorney, the government will provide you with legal counsel, with an attorney. Only in those situations, keep in mind, of punishment being a minimum of 6 months in jail or more. And that concludes Lesson 42 in our Supreme Court cases on due process.